I'm Wade Henderson. I'm president of the Leadership Conference on Civil and Human Rights and the Leadership Conference Education Fund. I'm also the Joseph L. Rao Jr. Professor of Public Interest Law here at the University of the District of Columbia's David A. Clark School of Law. Well, as you know, the U.S. Supreme Court rendered a decision in the case of Shelby County versus Holder. It was a case that examined and challenged the constitutionality of the Voting Rights Act of 1965. The Voting Rights Act, along with the Civil Rights Act of 1964, are arguably the most significant legislative accomplishments and changes of Congress in terms of advancing equality. Over the years in which the Voting Rights Act held sway, it has been reauthorized 3 or 4 times. It has been modified to include language minorities and to ensure that there is protection for persons with disabilities. All of those things have been accomplished with the Act. And the Voting Rights Act itself has helped to transform America for the better and to perfect American democracy. It's premised on the recognition that if you don't vote, you don't count, and that voting is the language of American democracy, and that the Voting Rights Act was intended to ensure that this country lived up to its promise. What is especially ironic about last week's decision is that the 15th Amendment to the Constitution, which guaranteed the right to vote, the 14th Amendment, which of course guaranteed citizenship, were hard-fought struggles who, even after their passage, there was extraordinary resistance on the ground in helping to implement these requirements and to ensure that the requirements lived up to their promise. The Voting Rights Act of 1965 was born from the fact that the constitutional promise of the 14th and 15th Amendment could not be fulfilled on its own. They were not self-executing laws. They had to be supplemented by legislative mandates born from empirical data that there was widespread, deep institutional discrimination that, if not addressed, would suppress the vote of a segment of the American population, and that was simply wrong, both morally and legally. So the Voting Rights Act had that genesis. Now, when the decision was rendered by the court, I was profoundly disappointed, but I was not surprised. But to a degree, I was actually shocked. I was disappointed for obvious reasons. I was not surprised because the Roberts Court, in its narrow 5-4 majority, has shown itself to be the antithesis of what Chief Justice Roberts promised at his confirmation hearing, which was that he analogized himself to a baseball umpire simply making calls of balls or strikes with respect to the legal cases before him. What this case shows, what the Shelby County case shows, is that here is a Chief Justice who is an activist at heart, who is the opposite of a conservative, which implies a level of cautious review of legal and statutory precedents. It's one that gives deference to the appropriate role of Congress as defined by the Constitution. This decision shows that he's completely the opposite of that. This was an activist decision that was sweeping in its scope, even though it could have been framed in far more narrow and respectful terms. It's a decision that ignored the role of Congress as mandated by the 15th Amendment's Section 2, which explicitly authorizes Congress to remedy examples of discrimination that may exist in voting. And it was a decision that, in effect, slapped the Congress by saying that your deliberative review, 15,000 pages of transcript, untold numbers of hearings, and an overwhelmingly bipartisan vote in both houses of Congress, 390 to 33 in the House and 98 to nothing in the Senate. That record means little in this instance of congressional review. What really I thought was profoundly troubling, I guess two things. One, this case really seems to reflect the adage of William Faulkner that the past is never dead, it's not even past, and that this was a decision that was born in the ongoing struggle of the Civil War in the United States. We are still, in an ideological sense, and in some sense that you can identify with real examples, we're still struggling to resolve the conflict of the Civil War. But then secondly, it showed an individual who obviously is incredibly bright, but also one whose intent was born years ago when he was a law student, when he graduated and worked for the Department of Justice, when he clerked for Chief Justice Rehnquist. There is a record which shows that the intent of the Chief Justice to overturn the Voting Rights Act has deep roots, and that this was an opportunity seized to do that, to achieve that result. In another sense, I was shocked because it was so incredibly bold and ahistoric. I mean, it really reflects the general ignorance of the American public about the history of our country and how difficult it has been to achieve lasting change without additional elements beyond those promised in the Constitution. Oh, I think there's no question about it. I mean, I think this is a Chief Justice who, as with most Chief Justices, is concerned about the legacy of the court over which he presides. And no Chief Justice wants to be seen as decision-oriented to the extent outcome-oriented, to the extent that they write a decision to achieve a particular outcome. I think that you have seen instances where the court has used subtle, sometimes manipulative reinterpretations of what the Constitution requires to avoid that kind of condemnation. And so this Chief Justice in that regard is no different. I do think, however, that some of his views are shaped by several things. One, his own personal life experience has been pretty restrictive in terms of his exposure to the diversity that makes up America. His upbringing, his involvement in the profession is largely, a sort of a white cultural experience, a European cultural experience. Secondly, I think that he is both legally and ideologically quite conservative. I also think that this decision was made possible in part by the presence of Justice Thomas, who gives legitimacy and cover to those who would seek to remove what are characterized as racially motivated benefits to address constitutional impediments. And as long as Justice Thomas uses a sort of pseudo-nationalistic, ideologically conservative view to justify the complete elimination of racial considerations in policy areas where race remains an important factor, then that gives license to people like Chief Justice Roberts to reinterpret the court consistent with his own ideological views. All of that is to say that this was a court striving to achieve the 5 votes that it secured in Shelby County to overturn the Voting Rights Act. And it would do so as well in the area of affirmative action policy or in other areas where race remains a factor if the circumstance permits. Look, I have known Justice Thomas personally before his appointment to the Supreme Court. I opposed his confirmation. I was then the director of the Washington Bureau of of the NAACP, which meant that I was the NAACP's lobbyist in Washington. And in the course of the decision of the NAACP to oppose his confirmation, it was a vote of 50 to 1. Board members who appeared at a special briefing to hear the presentation that I and others made to justify the opposition to Justice Thomas. Finally, we prepared a report, the NAACP's report on the confirmation of Justice Thomas, which the board used as the basis for its opposition, was thorough and comprehensive in its review of Justice Thomas's writings as a judge in the D.C. Circuit Court of Appeals, his work as an executive within the administration. He was head at the EEOC and also served in the Department of Education, and analyzed the scope of his public statements on key issues of concern. So the opposition to Justice Thomas was not lightly taken. It was topped, by the way, the report I'm referring to now, with an epilogue drafted by John Hope Franklin, the great historian whose book From Slavery to Freedom is the standard basis for evaluating that segment of history. All of that led us to conclude that Justice Thomas would not serve the American interests well, and would in fact use his own personal experiences and pain to reinterpret the Constitution's role in helping to right the wrong of slavery in American life and to advance a broader set of goals related to American democracy. So in reading Justice Thomas's decisions from his 20 plus years on the bench, almost 25, I think what one sees is a couple of things. His personal pain at being on what he considered the wrong side of the color line, and what he considered to be a disadvantaged person in American society. That pain is quite evident. Secondly, he has masked his analysis in a pseudo-nationalistic basis of sort of suggesting that as a black person, his dignity is somehow affronted by availing himself of the advantages that have been created largely since President Johnson's time in the White House to rectify in a compensatory way some of the problems that still exist in American life. That combination of personal pain and a sort of pseudo-nationalistic view of how these programs work has led him, for example, to contemn the benefits of an affirmative action program in higher education, even while he himself benefited from those programs. So, I mean, there is a sense of irony and contradiction and deep confusion in the writings of Justice Thomas. What he has done in his role as a replacement for Justice Marshall, Thurgood Marshall, is, from my perspective, untold damage. And as I mentioned earlier, I think he gives legitimacy to a conservative wing of the court that would not be willing to be so bold in its use of its power to strike down programs were Justice Thomas not there to give it aid and comfort. But that is the hand to which we are dealt with, and let me just say, I think back on the men and women who really helped transform this nation for the better over the life of the 20th century. And I know that the struggles they faced were far more severe than the struggles we face today, far more severe. And yet they achieved success. And they achieved success because they wrapped themselves in basic American values of equality, of opportunity, of the significance of what this country represents to the rest of the world. They wrapped themselves in the American flag to use that as a symbol of what they are trying to accomplish, which is why the flag means so much to me personally. I refuse to cede the symbolism of American democracy to those who oppose our view for an inclusive society. It is not simply a symbol of those who would sort of hide behind it as a isolationist or restrictive token. Quite the contrary. It means a great deal more to those of us who see America as an open society in which democratic values mean everything. And so that's where we are.